Greetings, everyone. My name is Chris Chalenza, and I'm the James B. Knapp Dean of the Krieger School of Arts and Sciences at Johns Hopkins University.
Hi, everyone. My name is Bill Egginton. I'm the director of the Alexander Grass Humanities Institute, also of the Krieger School of Johns Hopkins.
Bill, I'm delighted to be working together with you and the Grass Humanities Institute on this new series on the ongoing crisis in the Middle East. It's got global significance, far-reaching implications, and it's something that is certainly still a part of our world.
I am too, Chris. This has been something we've been working on together for several months and really in conjunction with a very dedicated team of faculty who've been thinking deeply about the implications of the crisis in the Middle East and their roots, but also what it means for college campuses and for education and for communities of learning.
And in this dialogue and in the others in the series, I think what we'll see is something we value in an academic context, which is people bringing evidence and argument and reflecting different positions in the context of the same conversation.
I think that's exactly right. We began this series really at Hopkins with a series of with a panel discussion of Hopkins faculty representing radically different opinions about what was going on, and nevertheless managed to pull off a very large event where people were collegial, listening to each other, and this is what we're trying to do on an even larger scale right now.
That's right, Bill. Well, to close then, why don't we jointly thank the speakers, the moderators, and the viewers for contributing to this academic endeavor. And we hope that all of our viewers join the upcoming sessions and explore the complexities of this pressing issue.
I agree. Thank you, Chris.
Good evening. Thank you for joining us today. I'm Sarah Wildman. I'm pleased to be joining you as host and moderator of the final of our 5-part virtual discussion series titled Conflict in the Middle East, Context and Ramifications. This series, sponsored by the Alexander Grass Humanities Institute at Johns Hopkins University, has been exploring the long-standing tensions between Israel and Palestine, the political and social implications for both sides, and the broader regional and international impact of the conflict. We've been hoping to provide an in-depth analysis of the ongoing war and conflict, focusing on historical roots, current dynamics, and potential pathways to peace. Tonight's discussion is titled International Law in the Israel-Palestine Conflict. Over the next hour, we will examine the role of international law amid the current landscape of violence and conflict in the region. Our speakers will go over the challenges of enforcing accountability and how legal frameworks influence complex diplomatic strategies across nations around the world. Joining us for this timely and important conversation are Kevin John Heller, Marty Lederman, and Hala Khoury-Bisharat. Kevin John Heller is the professor of international law and security at the University of Copenhagen's Center for Military Studies, which is part of the Department of Political Science. He is an academic member of the Doughty Street Chambers in London and a member of the advisory board, the Bar Human Rights Committee of England and Wales. He also currently serves as the special advisor to the prosecutor of the International Criminal Court on War Crimes. Marty Lederman is a professor at the Georgetown University Law Center, where he teaches and writes on constitutional law, international law, and the laws governing the use of military force. He has twice served as Deputy Assistant Attorney General in the Office of Legal Counsel at the U.S. Department of Justice. Hala Khoury-Bisharat is a lecturer at the Ono Academic College School of Law and the academic director of Haifa campus, and adjunct lecturer in the law faculty at Tel Aviv University. Her main research interests are the fields of public international law, international criminal law, transitional justice, and human rights. She received her PhD from the University of Oxford. Before we begin tonight's discussion, I'd like to remind those of you tuning in live to submit questions using the form linked in your reminder email or on the QR code apparently displayed on your screen. We'll be monitoring the conversation, and we will do our best to respond to as many questions as we can towards the end of our broadcast with our Q&A session. I'd also like to thank the Hopkins at Home team for their production assistance, which has been tireless, and the Johns Hopkins Krieger School of Arts and Sciences and the Alexander Grass Humanities Institute for their tireless work putting this program together. If you're not familiar, AJHI aims to advance humanities scholarship and teaching at Johns Hopkins and promote literature, art, philosophy, history, and other cultural studies in Baltimore and the wider community. And now I'm thrilled to begin our conversation. I'd like to open it up. We will go around the room several times, but I'd like to start by looking at the two courts of justice in international law, the International Criminal Court, the ICC, and the International Court of Justice, or ICJ. And I'd actually like us to define what each of those are, because I don't think that it is well known that they are distinct entities and what each does. I'd like to turn first to Kevin, who I think has a caveat before he begins.
Thank you, Sarah. It's a pleasure to be here. Thanks to you and to Hopkins and to all of my co-panelists. Yes, I am not appearing tonight on behalf of the Office of the Prosecutor. I might refer to its work and might use the pronoun we, but I'm appearing solely in my academic capacity. So you've asked about the difference between the two courts, and I agree with you that there is an awful lot of confusion in this area. Basically, there are simultaneous proceedings involving Israel and Palestine in both courts. We have the International Court of Justice, often called the World Court. That is a court that is populated solely by states and adjudicates the responsibility of states for committing internationally wrongful acts against each other. There is a current case brought by South Africa against Israel, alleging violations of the Genocide Convention. That is in the middle of the proceedings and not the court that I am a part of. The court that I'm a special advisor for is the International Criminal Court. It is a completely independent international organization. We do not deal with the responsibility of states. We deal with the responsibility of individuals for violations of international law, in particular, war crimes, crimes against humanity, genocide, and acts of aggression.
Marty, what are the there were arrest warrants issued by the ICC for both Israel and Palestine. Can you outline for us what those were?
Sure, although I'll defer to Kevin to describe the warrants issued to get for the arrest of at one point 3 different Hamas leaders, all of whom are now presumed to have been killed, and so those warrants are no longer operational. The 2 warrants against Israeli officials were against the Prime Minister Benjamin Netanyahu and the former defense Minister Yoav Gallant. The thrust of the charges that the ICC has alleged, that there's probable cause to believe those 2 officials are responsible for, is that they are part of a common plan, and presumably that the 2 of them are personally engaged in a common plan by the state of Israel or by Israeli officials to starve. The principal allegation is that there's a deliberate effort to starve the civilian population of the Gaza Strip, and in order to advance certain war aims, and that they conspired with other government officials to do that, and that explains that the denial of certain humanitarian aid into Gaza, or restrictions that Israel has placed on such aid, including both food and water and electricity and other forms of aid, are deliberately designed are certainly, it's anticipated that it will result in starvation of the population, and that is actually the objective of the Israeli government and of these 2 individuals in particular who are part of that common plan. Like most arrest warrants issued by the ICC, the evidence supporting those claims are not entirely made available either to Israel, to the parties, or to the public. In this case, I believe, Kevin can correct me if I'm wrong, the chamber actually provided more information about at least the theory behind their claims than it usually does, but very little evidence that is actually the intent of Israeli officials to starve the population. I think the reaction in Israel that these charges seemed absurd was principally grounded on the idea that, of course, starvation is not the objective of whatever steps Israel is taking to regulate how aid is going into the Gaza Strip, but that Israel is instead, to the extent it's limiting aid or being reluctant to provide such aid, and such resources into the Strip, it is doing so principally in order to prevent Hamas from being able to exploit such material, to abscond with such things and to exploit them in order to strengthen its own hand in the armed conflict between Hamas and Israel, and or that Hamas is putting barriers in the way of such aid getting to the people who need it in order to raise money for their own military purposes. So the case turns on an allegation that there's probable cause to believe that these two individuals and others in Israel are doing this in order to starve the civilian population. It's a bit more complicated than that, and we can get into the granular details if any of your audience is interested in that. But in that respect, it has a lot in common with what is going on in the ICJ, in which the South African petition is styled as an effort to engage in genocide against the Gazan population. And again, that framing of it is resisted to a great degree by not only folks in Israel, but outside it. But it's pretty clear from some of the opinions of the jurists on the ICJ that what they're really concerned about, and this is the sort of the through line in both cases and in other contexts, is that Israel is using the denial of aid in order to, shall we say, coerce the civilian population to throw off the shackles of Hamas or to do what it can to weaken Hamas, and to use such aid as a bargaining chip in negotiations with Hamas, both for the return of the hostages and otherwise. To the extent Israel is doing that, and again, these are just allegations, to the extent that is the reason, that would, I think, pretty clearly violate the law to use the denial of aid as a bargaining chip or to coerce the civilian population. But the principal dispute on the facts is whether that is actually Israel's objective, something that we can't really tell based on the evidence that we currently have, or at least can't determine definitively based on the evidence that we currently have.
I want to pause you for a moment and go to Hala and ask, obviously, Hala, you're there in Haifa and you're also teaching Israeli law students. I wonder, Marty mentioned how it was received in Israel. How was it received? I mean, how did your law students receive it? And how did the Israeli Bar Association receive the response?
They were really shocked and appalled by the decision of the prosecutor, and they didn't imagine that, they say we are a democratic country, and it cannot be that, I mean, the Prime Minister and the Minister of Defense will be prosecuted in the ICC. It's ridiculous. It cannot be. We cannot imagine. So they were really astonished, appalled, resisting the thing, attacking the court, attacking the prosecutor, saying they're anti-Semitic, and very, very angry. They felt really, really angry that this is happening. So yes, so they were attacking the students. They want to know, the students want to know why it's happening. Yes. So we talk about the law, what it is, what's going on. So I try to explain why the ICC, why the prosecutor, the office of the prosecutor has decided to issue these arrest warrants. So they really feel that, the whole world is just targeting them. It's always been like why we are targeted, why we are always, being attacked. But there's a big picture here, and I try to tell them that there's a war going on, and there's a policy and of a government, and there are a lot of casualties on the ground, both sides, after the horrendous massacre in 7th of October, the atrocities that Hamas did on the 7th of October, and then Israel started its assault, its war on Gaza, which it's this horrendous results, horrendous pain and suffering of the civilian population in Gaza. Like Gaza is wiped out. No, all the civilian infrastructure is destroyed. All 2 million people are being displaced from their homes. no medical centers, no health, centers, clinics, hospitals were being targeted. So all the civilian infrastructure is wiped up. Medical staff are being attacked. We just heard there are many incidents about that. So it's a very complicated situation.
I'm going to pick up on something you said, Hala, about, and there's two issues that you've just raised that I'd like to turn to Kevin with. One is this question of, is Israel being attacked specifically and held to a different standard than another country might be? And the other is something that you mentioned sort of briefly, is that Israel is a democracy. And it gets to this question of a word, complementarity, which is something in the circle of the three of you is used often, but not among lay people. And I would love someone to first explain complementarity. And I don't know if Kevin, I know you wrote an essay on this because a number of American politicians actually took issue even with the pretrial questions of arrest around the idea that Israel had not had enough time to investigate and what it looks like. And are these courts of last resort if democracy is not living up to itself? So let's start with that and then go to this question of, is there a second standard for Israel? Is Israel looked at differently?
Sure. So let me begin with complementarity, and it is one of the foundational cornerstone principles of the ICC. The ICC is designed to be a court of last resort, but complementarity has a very specific meaning as it's used at the ICC, and it's important to understand what that standard is. When there has been an arrest warrant issued for an individual suspect, complementarity allows a state to take essentially jurisdiction away from the court if it is investigating or prosecuting the same suspect for substantially the same conduct that the ICC is investigating and wanting to prosecute that person for. Nothing short of that is enough to make the case, as we say at the court, inadmissible. It is not enough to be investigating other suspects, no matter how high-ranking they might be. It is not enough to be investigating the same suspect that the ICC is interested in, but looking at different crimes and different conduct. Again, same suspect, substantially the same conduct. That's the standard. This is not in any way commenting on the quality of Israel's democracy. It is not commenting in any way on the quality of Israel's judicial system. We don't pass judgment on governments. We don't pass judgment on criminal law systems. We pass judgment on whether states are genuinely investigating or prosecuting the same suspects for substantially the same conduct. That's it. And at no point in time has the court taken away Israel's right to satisfy complementarity. It has every right tomorrow to start investigating Netanyahu and Gallant for substantially the same conduct that the OTP is investigating. And at that point in time, if they're genuinely doing that, the court would step aside and allow Israeli courts to run their course. But there has been no indication that that is in fact the case. So the principle of complementarity, no matter how foundational, simply is not yet an issue in this particular situation.
Then the second question.
As for the second question, I think this one is really important. Israel is not held to a different standard than any other individual or any other state. We hold all suspects to the same standard, which is the Rome Statute of the International Criminal Court, the foundational document. And if you look around the world, you can see that particularly Netanyahu, the head of state, is not in a class by himself in terms of attracting the ICC's interest. There are arrest warrants against Omar al-Bashir, the former president of Sudan. There is an arrest warrant against Vladimir Putin of Russia. There have been applications for arrest warrants against the supreme leader in Afghanistan. There are arrest warrants currently pending for the one of the supreme leaders in Myanmar. Rodrigo Duterte, the former head of state in Philippines. He's currently in ICC detention and he will be facing trial in the near future. There are plenty of other heads of state that have drawn the attention of the court. And so what you often hear, and you hear this particularly from American politicians, is why not any Iranian government official? Why not Bashar al-Assad in Syria? Why not Xi for the genocide of the Uyghur in China? And there's a very simple answer to that, which is we don't have jurisdiction over those crimes. Those are crimes committed on the territory of that state, and that state is not a member of the ICC. If in fact they were a member, we would be investigating those situations like we would investigate any others. But there is no jurisdiction, so that's the reason that you don't see an arrest warrant against someone like, Assad.
Marty, I am curious about all of the examples that Kevin just gave us. Obviously, every example is slightly different. And what I'm imagining that you would hear from Netanyahu and Gallant is October 7th happened, and this was a response as opposed to a proactive action. And I wonder if there is a difference in terms of the question of whether something is abrogating humanitarian laws of humanitarian action, and that's not the right way of phrasing it, but is there a difference in terms of reactivity versus and defensive action, if how Israel might describe it, versus the actions of, for example, Putin engaging in Ukraine?
So not if the allegations were true, right? So a deliberate effort to starve a civilian population for whatever reason, for bad reasons, genocidal reasons, or even in order to coerce Hamas to come to the bargaining table and release the hostages. I don't think anyone argues that that would be permissible under the law, even if Israel's broad objective and broad claim to be able to act in self-defense against Hamas is legitimate, which I think most observers think it is. To a certain extent, certain means of warfare are off limits, and starving a civilian population is one of them. What I really found striking as I started getting into this issue is that was the disconnect, right? The objections from Israel and Israeli defenders, quite understandably, where they thought what the ICC was doing here was simply equating Israel's actions with Hamas's actions on October 7th and saying that equivalence is morally objectionable. It's obscene to suggest that those things are equivalent. And of course, in some respects, it is, right? There's no question, no one denies that the actions taken by Hamas largely against civilian populations on October 7th were grotesque violations of the laws of armed conflict and many other legal systems.
Were
And,
those war crimes too?
and there's
Would
I'm sure they probably were war crimes. Yes, you'd have to meet certain predicates and criteria, but whether or not they're war crimes, they're clearly illegal, and Hamas is not arguing that they're lawful, nor is anyone else that I know seriously arguing that they're unlawful. It is not simply that Israel is fighting against Hamas, in fact, fighting quite aggressively in a way that has the results that Hala described, that is the basis for these claims. The basis for these claims is the allegation that there's a deliberate effort to starve the civilian population. I think if folks understood that, they would have one of two reactions. One would be, if those claims are borne out, those are violations, right? And there's no question about it. But I think there's some incredulity in Israel. You can't just claim that that horrifying objective was shared by these government officials, and that's what's going on here. And this ties into the complementarity question. Israel was claiming, you're just making these allegations, but you're not telling us what the basis is for thinking that we're doing this in order to starve the civilian population. If you gave us that evidence, maybe we would investigate it. We'd be happy to investigate it if those would be horrible allegations, and we would investigate it. But you took us by surprise by accusing our officials of having this deliberate plan to starve the civilian population. Now, I will say, to a certain extent, what the ICC did, if not has been overtaken by events, and I know we want to get into this a bit, has sort of, the playing field has changed in several ways, including changes in Hungary and here in the United States in our perspective with respect to the ICC. But even on the starvation claims, two things have happened very recently. One is that a panel of the Israeli Supreme Court actually decided a case that had been brought before it, arguing that the denial of humanitarian aid was unlawful. And that court, and that was one of the things Israel held out as a demonstration that we can investigate these things, we can adjudicate these things. And they held that, for the most part, Israel's denial of humanitarian aid was not unlawful, but with some caveats. but did not really address the allegations of deliberate starvation. As far as I know, it hasn't been translated into English, but those who have read it in Hebrew tell me that it doesn't really address that issue. But then the second thing that happened was that in March of this year, I believe it was March, let me just get the date out to be certain. Sorry. There was a statement by the defense minister in Israel that was basically a message to the Gazan population, which is you will be destroyed and your way of life will be rendered completely um, destroyed unless you can somehow help us get rid of Hamas here. Sort of suggesting that, at least with respect to that one official, the objectives here really are to use the civilian population as a cudgel to try to defeat Hamas or to change Hamas's posture in the negotiations. A very, very disturbing development, I think. It doesn't mean that Netanyahu and Gallant had that same objective or that same intent to harm the civilian population, but I think it's becoming more and more acceptable, at least for some officials in Israel, to be more openly saying that we are trying to use the civilian population as a means of achieving what might otherwise be legitimate war objectives. But that's an illegitimate means if they are doing that.
I'm glad you brought that up because, Hala, I want to turn to you because actually, though in March that was a particularly extreme statement, throughout the course of the conflict, there have been statements made by Israeli officials where they indicate that they will cut off electricity and cut off aid trucks. I think actually at the very beginning of the conflict, not long after October 7th, there were similar statements, perhaps not as extreme. And I wonder how those statements are heard within Israel and how you see them in a legal framework given that that's the literal legal framework that you live within.
Yes. We're talking about allegations of incitement to commit genocide. So, and the ICJ in the provisional measures, one of the provisional measures that the ICJ in the South African application to the ICJ against Israel on the issue of whether what's going on in Gaza is genocide or not, the court said that Israel should investigate these incitements. And in Israel, nothing has happened. The Attorney General, the state attorney has closed all the investigations, all the cases. And the reason they say there is no public interest to investigate these incitements. I mean, these declarations, these words of these ministers and officials. And what I'm saying, Sarah, is that what is going on in Israel now is a state, is a democracy in crisis. The current situation in Israel is bad in a way that, you know, the State of Israel representative in the ICJ, he said when the cannons of war roar, sorry, in Gaza, then the law is not silent in Israel. But I want to tell you, Sarah, the law is deaf in Israel, is silent. It's paralyzed. The rule of law is paralyzed now when it comes to the functioning of the Supreme Court, when it comes to able and willing. What is going on now, it's that the legal system of Israel is not only unwilling, it's unable to conduct investigation, effective, genuine investigation of the violation that's happened or happening again. It's going on in Gaza. We see it's like the Supreme Court in previous wars over Gaza, in Gaza, the Supreme Court, NGOs, human rights organizations used to submit petitions to the Supreme Court. The Supreme Court used to say to the army, stop doing that, let the ambulances go in. What we see in this current war, the Supreme Court of Israel is paralyzed. It's not, we see petitions on the situation of prisoners and the torture and the sexual abuse of Palestinian prisoners. The court doesn't interfere. It's pending. The petition on this issue is pending over a year. And now, today, we heard the 18th application from the NGOs telling the court another petition to allow the ICRC, the Red Cross, to visit the Palestinian prisoners, they don't deal with it. They're not doing anything about it. The court is like freezed. So, and vis-a-vis able and willing, when Kevin talked about the complementarity, because the ICC is, a case is admissible before the ICC is inadmissible if the state that has jurisdiction is able and willing, is conducting real effective investigations. Sarah, there's a policy, consistent policy, when it comes to Palestinians' lives. No real investigation, no effective investigations are being conducted by the Israeli military. And we have data, we have statistics from Yeshdin, from B'Tselem, from many NGOs in Israel that show us in all the cases, I mean, the army declares we opened investigations. The army specific unit is doing preliminary examinations in order to decide whether to open a criminal investigation or not. And we just hear about the opened investigations, but we never hear about results. We never hear about indictments. It's a policy of impunity that is reigning when it comes, again, to Palestinian lives. It's not the first time. It's not the first war. Even in the past, no actual investigation, no effective, genuine investigation, and no indictments ever against any soldiers, and specifically any high-ranking officials or high-ranking military personnel.
I'm gonna, yeah. No,
Yeah.
I'm sorry, I don't mean to cut you off. I'm
Okay.
conscious of that we're getting in questions, and I want to come back to you. I will come back to you on part of this, and also a little bit more about how the population is actually seeing what's happening or not seeing what's happening. I'd like us to return to that. But before we do, actually, one of our watchers asked a question that I had in my list as well. Kevin, I wonder if you can actually just define for our audience what a war crime is and who gets to define that.
Sure. There's a very technical definition of a war crime in international law, and the definition is simply this. It is a violation of international humanitarian law or the law of armed conflict, whichever term you prefer, for which international law actually imposes individual criminal responsibility. There are some violations of the laws of war that are not war crimes. The most serious ones are war crimes. There is no definitive list in international law of what is a war crime, but the most definitive list that we have is, in fact, the Rome Statute of the International Criminal Court. It lists approximately 55, maybe 60, I haven't counted them recently, individual violations of the laws of war that qualify as war crimes and that can be prosecuted by the ICC. Now, in terms of who decides whether they get prosecuted or whether they've occurred, the simple answer is ultimately the judges of the International Criminal Court in a case over which there is jurisdiction. All we can do, all the Office of the Prosecutor can do, is make allegations and introduce evidence to try to prove a case. And at every stage in the process, there is a standard of proof that the office has to satisfy in order for the court to move forward, or for the proceedings to move forward. Right now, we are at the most simple stage. An arrest warrant should be issued by the judges if the Office of the Prosecutor establishes a reasonable basis to believe that one of these war crimes or crimes against humanity have been committed. It's a very, very low standard. At the next stage, if there is actually a suspect in custody, we have to prove at the confirmation of charges hearing that there's clear and convincing evidence or substantial, there's another standard of proof. But ultimately, of course, the decision as to whether someone has committed a war crime is decided by the judges, and that has to be proven. Every element of the crime, just as in any ordinary criminal law system, has to be proven by the prosecution beyond a reasonable doubt.
How did the prosecutor gather evidence to even issue the arrest warrant?
It's an excellent question. And the International Criminal Court and the Office of the Prosecutor often faces difficulties in obtaining evidence. Israel has never allowed the prosecutor or any member of the Office of the Prosecutor to actually go into Gaza to investigate. Despite that, the office has been able to gather a considerable amount of consistent, internally corroborated evidence over a many month period of the investigation. The investigation relied on testimony from victims and witnesses, including doctors, lawyers, NGO workers, government officials actually on the ground in Gaza. It's relied on a vast amount of audiovisual evidence, you know, cell phone recordings, videos taken that are submitted anonymously to the ICC via an encrypted system and then actually analyzed using kind of very high-tech AI and artificial intelligence. It relies on statistical data produced by national and international organizations. It relies on satellite visuals made available to the court. And very importantly, in this particular situation, and you already alluded to this, the cases rely on inculpatory statements made by the suspects themselves. And for both Hamas and for the Israeli suspects, there is considerable number of statements that are inculpatory.
Oh, sorry.
No, I did want to push back, or not push back a little bit, but offer a bit of a corrective to our listeners who are asking about war crimes. Just to make clear, I agree with what Kevin said, that the question of whether something is a war crime requires a heightened degree of proof of particular mens rea, in particular, state of mind in particular, or clarity of the violation of the law. I think the three of us probably largely agree that it is very unlikely that anyone will finally ever be tried and convicted of war crimes in any of these tribunals. We can discuss the reasons why for that. But just wanted to make clear that even if that doesn't occur, that doesn't mean the conduct is lawful. Long before one gets to a war crime, there are laws that govern the conduct of war, laws to which Israel is and historically has been quite devoted and insistent be honored and be complied with, even if they are not subject to criminal sanction in an international tribunal. And I think that is, you know, I think it's a mistake to focus too much on just the prospects of convictions in these two tribunals or in other tribunals, because I think the larger question is whether Israel and Hamas complying with the laws of war in their conduct, even if Israel's overall objective is a legitimate one, which is to protect its civilian population from being attacked. There are real questions about the proportionality of its conduct, in addition to the starvation allegations, that I know we'll get into if we have time, depending on our audience here and where this turns. But those things won't necessarily result in any trials or convictions, but they still raise pretty profound questions about compliance with the way that wars are permissibly fought.
I'm glad you brought up proportionality, actually, and I do think we should address it briefly. And then we'll turn back to Hala, because it is something that we all discussed in our prep call, which is the question of if each individual strike is perceived as proportional, the overall effect may not be seen as proportionate. And how do we determine proportionality in a conflict and a context like this one, which is a regional war in a very, very small space with a very large number of civilians, where protecting civilians, as much as Israel has purported to protect civilians as much as possible, protecting civilians in this context seems a nearly impossible task at best. And I'm curious how we can think about proportionality in this context and how it plays a role in how the question of war crimes or unlawful warfare takes place.
So I'll start and then really want to know what Hala and Kevin think about this. This is obviously a very, very complicated and broad subject. And in fact, it's two distinct subjects, or it has been treated as two distinct subjects. One is that there's a requirement that the military campaign as a whole, be proportionate to the legitimate self-defense objectives that the state is seeking to achieve here. And that is famously a contested question of how one assesses that. What proportionate in what respect? I think the general intuitive layperson's reaction here is surely it can't be proportionate on the whole to render, a plot of land on which 2 million people live to be completely uninhabitable, with great destruction and this sort of thing. It's not clear under the law, just to be honest, whether that really is something that the law deals with, measuring the overall civilian harms to the overall military objectives under what's called the jus ad bellum, the reasons for beginning a campaign. But even the second one, which is much more well established, which is that each attack has to be proportional. There, at least the rules are more well established and agreed upon. It has to be that the anticipated, it cannot be, even if you are targeting legitimate military targets and doing so for the best of reasons, the anticipated harm to civilians cannot be excessive in relation, the anticipated harm to civilians cannot be excessive in relation to the direct and concrete military advantage that you expect to achieve by virtue of that attack. Now, that is comparing apples and oranges famously in a way. How do you measure? What does it mean to measure excessiveness of civilian harm to military advantage? But I think there's a great deal of concern that even on the individual attacks, the Israeli Defense Forces are using a measure of proportionality that seems quite almost indefensible. And I'll give you one very, very concrete and vivid example. On the day after the ceasefire ended, that was on March 18th, the IDN and Shin Bet had engaged in an attack for arguably a legitimate purpose, which was in order to kill or take out a Hamas operative who was running their civilian government. There is a question of whether that person was a legitimate military target, but Israel publicly announced that it had successfully killed 4 high-level Hamas individuals and that would provide some military advantage. Even if that is true, which remains to be seen, the attack resulted in over 400 civilian deaths, including over 180 children. Now, Israel might argue that those civilian deaths were unanticipated, but it appears, just from what we know so far, as though they had to have anticipated huge numbers of civilian casualties for the benefit of killing these 4 Hamas operatives. It's hard to imagine any theory of the law of proportionality in which that is not excessive and therefore a violation of that law of armed conflict. Now, that's probably being investigated. Hala might be right that who knows what that investigation looks like. But if Israel believes that or anything like it to be proportional, then the very important principle of proportionality has lost all of its impact, I would think. That seems, grotesquely disproportionate.
Hala, I'm wondering, we spoke about this a bit the other day. What does the Israeli population see of that kind of attack? Whereas in the United States and around the world, there are often images on our media, social media, in newspapers we read, where we might see the aftermath of such an attack. What are you seeing in Israel in the media, and how is the reaction after that?
The Israeli media, except for the Haaretz newspaper, all the media, they show nothing about Gaza, nothing what's going on. They don't show pictures. Now, only lately, just a glimpse, one picture very quickly. They don't show you the destruction, like they don't show you the killings, the 50,000 victims. They don't talk about it, nothing. The Israeli media ignores since October 7th. The other side doesn't exist in Israel. It doesn't.
In that
So,
context, given what Marty just said, how do you
yes.
talk about rules of war, such as they are, in your classroom among law students?
Well, among my law students, we talk about the rules of war, I mean, in principally speaking, but nowadays it's very difficult to get into this topic with Israeli students. It's very tricky. It's very, very tensed. It's because I'm a Palestinian, I'm an Israeli citizen, and I'm teaching them about international norms. So one student came up to me and she told me, please, Dr. Khoury, I can't hear examples. Don't give us examples about what's going on because I cannot bear it. I don't want to hear about what Israel is you know, what's happening. And I said, but you're an Israeli student, law student. We should know about these issues. We're learning. This is academia. So they don't want to hear about it. But what's going on, I said that the media, when it's not letting the Israeli public know what's going on, then people in Israel, they don't really have the information to get a stance, a real stance of the issue. They just don't see the other side. They don't care what's going on. So you see utterly, completely no coverage of Gaza, no coverage of the Palestinians in Gaza. So yes, this is, and it's consistent and it's going on.
We're getting in a handful of questions that are much more sort of concrete questions about these organizations. And one watcher, one audience member, has asked about the United States and the ICC and the ICJ. And I wonder, Kevin, if you can speak to the role or lack of role of the United States in these international criminal courts. Well, criminal court and the Court of Justice.
Well, I mean, the ICJ one is quite easy. The United States doesn't recognize the compulsory jurisdiction of the ICJ, which means that they can't be taken to the court unless there is some provision in a treaty to which both the complaining state and the U.S. are a party that allows them to get there. Obviously, the ICC is more my area of expertise. The U.S. is not a member of the court. The U.S. has no obligation to cooperate with the court because it is not a member. But that said, the Americans can't avoid the jurisdiction of the court simply because the United States is not a member. One of the basic jurisdictional principles of the ICC is that when a national of a non-member state commits an international crime on the territory of a state party, the court has jurisdiction. That's why we have the ability to seek an arrest warrant for Vladimir Putin. Russia, like the United States, is not a member of the ICC, but Ukraine has accepted the court's jurisdiction. It has recently ratified the Rome Statute and formally joined the court. And because Russia is committing crimes on the territory of a state party, that gives us jurisdiction. Same in the Israel-Palestine situation. Palestine is a member of the court. The court has said that they are a member of the court in good standing. And so even though Israel is not a member of the court and doesn't recognize the jurisdiction of the court, the fact that an Israeli national has committed an international crime on the territory of Palestine gives us jurisdiction over them. Now, that's controversial. The US doesn't like it in the context of Palestine, but it's worth pointing out that this is really a fundamentally hypocritical position because the same individuals who have attacked the ICC for seeking jurisdiction over a non-party like Israel were not too many months ago celebrating the court for bringing an arrest warrant against Vladimir Putin, even though the jurisdictional situation is exactly the same. Although there is a statehood issue, I see that Marty is smiling, and I don't want to get so far into the weeds in that particular issue. But the basic argument is still exactly the same. The way you avoid the jurisdiction of the court is to not join the court and not to commit an international crime on the territory of a state that has joined the court.
So
Now,
without getting too far into the weeds, I will say, and again, I was in the Biden administration, so take this with a grain of salt, if you will. The view of the United States during the Biden administration was to reject an old U.S. view that states that are not parties to the Rome Statute that their personnel cannot be held culpable under the law. The Biden administration clearly thought that was wrong. That's why Russian forces who violate the laws of war could be tried by the ICC. Kevin is right that there's a more discrete, that in and of itself appears to be under attack by the Trump administration and the current Congress. They might go to a more extreme view. But the issue that is before the ICC right now that Israel is complaining about is actually quite a difficult question, and it's very technical, and it's about whether Palestine and Hamas as the governing entity in Gaza in particular, is a state that had jurisdiction over Israeli nationals in Gaza to begin with, on the theory that if it did not, it could not confer such jurisdiction on the ICC. I've written that I think that question is extraordinarily difficult, and it's a very tricky one for the court ultimately to resolve. I just want to put it out there. It's not worth spending a huge amount of our precious time here on that. But there is this narrower theory, which is very unique to Gaza and to the Palestinian Authority and Hamas, that does not depend on the idea, the broader incorrect idea that non-parties are not subject to the court's jurisdiction.
What does that mean in terms of the ongoing problem of the hostages? For example, in terms of the fact that they are a non-state actor, there are still hostages there. What jurisdiction does the ICC have over Hamas such that it still exists?
Over Hamas. I, I, I think we shouldn't get into that just because it's extraordinarily complicated. It seems to me that Hamas taking hostages in Israel. Well, Kevin, why don't you speak to this, or at least what the perspective of the prosecutor was on that question?
Sure.
And why that
I think the OTP's position, the prosecutor's position, is very straightforward. That Palestine is a member of the court. The overwhelming percentage, if not all, of the individuals who are associated with Hamas and other Palestinian armed groups are nationals of the state of Palestine. And so it doesn't matter where they might commit an international crime. The fact that they're a national of a state party means that we have jurisdiction over them. And so, again, we deal with individuals. We're not concerned with, the nature of a particular group or a particular government. We're concerned with the activities, the actions of the specific individual.
I'm not sure if the logic of the Israeli-U.S. position, Sarah, would actually lead to the conclusion that even the members of Hamas who committed war crimes are not subject to the jurisdiction when they commit them in Israel, which is not a party. But Israel's not worried about that because they don't think that any Hamas individuals are ever going to be tried by the ICC either, and they're not clamoring for that to happen. So unless our viewers really want to get into the weeds on this, maybe we should just it's enough to say these jurisdictional issues are tricky, and they've been tricky for the judges on the ICC to deal with for years and will continue to be so going forward. And it's not clear to me how it's going to be resolved.
Well, there is a question that has come in that is connected to a bit about what I've just asked, which is one alumni from the School of Medicine says, how does one account for Hamas embedding itself deliberately within the civilian population, using hospitals as human shields or adding weapons in places where civilians are living? Is that also a war crime?
Yes. So the simple answer to that is absolutely yes. It is a war crime for any party to an armed conflict, Hamas, Israel, anyone else, to deliberately place its legitimate military personnel embedded in civilian areas in order to make the civilians there effectively involuntary targets, involuntary human shields. There's no question that Hamas, by doing so, and doing so in order to make it harder for Israel to comply with the rule of proportionality, is itself a violation of the laws of war. There's no question, no one disputes that Hamas is violating the laws of war. Now, what does that mean for Israel, right? This is the response I got from everyone when I've recently visited Israel. They were aware, I mean, they may not be seeing the destruction of the civilian population in Gaza, but they're pretty much aware that it's happening. And the consistent response is, we would love to not attack the civilian population, but it's Hamas's responsibility. They've embedded their troops in hospitals, in schools, in apartment buildings, in tunnels, under all such structures. And if we had to disregard, if we had to basically honor or apply the principle of proportionality the way you're describing it, Marty, it would mean we couldn't attack the Hamas operatives. We'd have to stand down. They would have successfully violated the laws of war and made themselves untargetable. What should we do in that situation? I think the answer under the law is clear, which is that that is not an excuse for you to engage in disproportionate attacks. Nevertheless, Sarah, there's no question that the world over, this is a fundamental problem with the law, is what do you do when one party to the conflict is making it so that if you attack them, you will almost inevitably be violating the principle of proportionality. Do you have to stand down? What should you do instead? This is a very, very tricky question. And I understand why people say that Hamas is principally responsible, to which I reply, yes, it is, but that doesn't absolve Israel of its responsibility to comply with the laws of war either.
I want to remind the audience really quickly that we are now entering into the time period where I would love more questions coming in. We have a handful that have come. You can pose them directly to Hala, Marty, Kevin, or
Sarah, can I just add something about the last question?
sure, go ahead.
Yeah. Well, we have to remember, Marty, and many incidents happened in Gaza, not only because it's not always that Hamas is, hiding hiding uh, behind civilian population. There are many incidents of bombing universities, of bombing hospitals and clinics, IVF clinics. No Hamas personnel were over there. I mean, many and even Israeli soldiers have used Gaza citizens as human shields when they entered buildings because they didn't want to be in danger. So they used the civilian population in Gaza to get into the houses. They kept them overnight as human shields with them as prisoners in order for them to help them to get into houses and to look for other Hamas, so they used the civilian population. So when we talk about Gaza, I mean, the world doesn't know what's really going on because Israel is not letting any outside, investigators, any neutral, any objective commission of inquiry to go in, to look at the fact, to see. Nobody's can go in. So, and also the ICJ was a provisional measure telling Israel, you should let, commissions of inquiry to go to the press, outside world, go into the area to see, to look, to investigate, to gather evidence, and it's not happening. So you only
Just don't,
hear,
yeah, I don't want to leave a misimpression. I agree with Hala. To the extent that is occurring among IDF forces, those are clear violations of the laws of war. I agree without regard to proportionality. That's just themselves using civilians as tools of war, which is impermissible.
Hala, you mentioned earlier that there is not an investigation. After 2014, one of the Israeli watchdog groups called Breaking the Silence had actually a deep investigation among the military that had been in Gaza during that incursion. Are groups like that working on similar efforts now? Has it changed?
No, these groups now are silent. I mean, you don't hear that even the human rights organization in Israel, I mean, they're doing terrific work and they're doing very important work, but there's a backlash against them. I mean, the political nowadays, the political atmosphere is very hostile. It's very hostile towards anybody who speaks about Palestinians, who speaks about the humanity, that there are humans in the other side. They don't want to hear about anything when it comes to Palestinians. Don't talk about human rights of Palestinians. Don't talk about, Marty, I have to tell you, and I don't know if you know, there is now an allegation that in Kele, in the prison of Megiddo, there is a policy of starvation inside the prison in Israel, where they held Palestinian prisoners. A policy of starvations. Prisoners are coming to hospitals, and I know a couple of physicians who work in these hospitals, and they say about the condition of these prisoners coming to hospital in a very, very bad shape. And it's clearly that these people are being tortured, are being, they are hungry. There's a policy. So when we talk about what's going on, about breaking the silence, you don't hear that nowadays because people are in fear. Also, human rights organization, there's also a law, a bill that the Israeli government wants to that the NGOs would pay 80% taxes from funds they get from foreign governments. So they are, they're trying to scare the NGOs, the human rights organization, by telling them, you be quiet, you don't do your job. Because if you do that, we're going to cut all the funds. We're going to tax the funds you're getting from foreign governors. So there's a real backlash on, like there was a backlash when the Goldstone report, when there was the war in Gaza in 2008, 2009, and there was the Goldstone report. And
Hala,
then
I'm
there
going to
was,
pause you because we're now getting
yes,
into spaces that we haven't really discussed. And I do want to
okay.
pull out a couple of the questions, and I apologize for cutting you off. We do such a short amount of time. I appreciate your comments. An Arts and Sciences alumna asks, and I'm going to throw this to Kevin, why is the ICJ not pursuing action against the Palestinian state, failing to pursue action against the Palestinian state and actions against those holding hostages, as well as those who carried out atrocities in Israel on October 7th, make the courts look biased against Israel? So I think she's referring to both courts. So I'm actually hoping that you might be able to address that.
I can cover both of them real quick. The ICJ one, again, is easy. The ICJ only deals with disagreements between states. If Israel wanted to file a case against Palestine at the ICJ, it could, but that would require acknowledging its compulsory jurisdiction. And even more importantly, it would mean acknowledging that Palestine is a state for purposes of the ICJ, and they're not going to do that. The ICC aspect, I think, is really, really important. There's a reason why we are only discussing tonight the criminal responsibility of two Israeli government officials. And that's because the three suspects from Hamas against which the prosecutor, or for whom the prosecutor sought arrest warrants, were killed by Israel in the interim. It's very important to remember that in May 20th of 2024, the prosecutor announced to the world not only that he was seeking an arrest warrant for Yoav Gallant and Benjamin Netanyahu, but also for Yahya Sinwar, the head of Hamas, also for Mohammed Daif, who is the head of the military wing of Hamas, and Ismail Haniyeh, who was the head of the political wing of Hamas. He alleged extremely serious charges against all three men, arguably more serious charges than the ones alleged against Gallant and Netanyahu. Those would have proceeded to be exactly in the same procedural situation as the arrest warrants currently, except while the pretrial chamber was deciding whether to issue the warrants in the first place, Sinwar and Haniyeh were killed by Israel. The pretrial chamber did actually issue an arrest warrant on very serious charges for Mohammed Daif. Those would have proceeded, except he was killed, or at least there was evidence presented to the court sufficient to convince the judges that, in fact, he had been killed at some point. So the reason it seems one-sided is because three of the suspects have been killed in the past 6 months. But the prosecutor has also been very clear that investigations are ongoing. He's made extremely clear that he is continuing to investigate, in particular, sexual violence committed by Hamas and a member of other Palestinian armed groups on October 7th against Israeli victims. There were sexual misconduct charges against Hamas in the original application for arrest warrants, but those charges really focused on sexual violence committed against Israelis who had been taken hostage. The more active part is about October 7th itself.
Thank you, Kevin, for that. There have been a few mentions of proportionality in the conversation, and a staff member had an earlier question on this. Is there anything in international law that deals with this? Are these unwritten norms that are supposed to hold nations in check? Marty, this is for you, I think, this idea of what are the norms around proportionality? And I think the one thing we might want to do is address when these norms came into play after the Second World War.
So the norms are developed in customary international law, not in treaty or in statutes or in criminal law, but they have been codified in an additional protocol to the Geneva Conventions. The principle of proportionality is codified there, and that is binding on the states that have agreed to that treaty, which I believe includes Israel. And the United States, which is not a party to it, nevertheless insists that it has an obligation to comply with the principles of proportionality. Both kinds that I talked about. The former is included implicitly, the overall proportionality requirement is included implicitly in the United Nations Charter, which is a treaty, and the latter is included in the additional protocol. So they do appear in treaties. They derive from customary law. They have been given, certain formulations have developed around them. The norm which is not really about proportionality, but distinction. The idea that we've discussed a bit, that you may not use the civilian population as a tool of war, even if you're doing so to try to bring the war to a quicker end. That is one that has developed, Kevin can correct me if I'm wrong, or Hala can, that was prominent in the 19th century, including here in the United States. It was largely thought to animate Sherman's march through the South, right? The devastation of the cotton crop and of civilian populations in order to bring the South to heel, in order to get them to surrender. It is largely thought to be at least a prominent objective in the bombing of German cities during the Second World War. Some say that it was largely behind the use of nuclear weapons, was to use terror against civilian populations in order to bring the enemy to end its campaign. That idea that that's permissible, whatever one thinks of the morality of doing that, I think it's fairly clear that the international community in the wake of the Second World War decided you can no longer do that. Whether or not you think it will bring the war to a quicker end, you cannot use harm to the civilian population or the threat of harm or the threat of starvation or the threat of displacement as a means of achieving even the most legitimate and most laudable of military objectives. So that is a relatively, in the grand scheme of things, a relatively recent norm. But it's one that I'm not sure that most non-law of war folks understand, because I think people do keep invoking those historical examples of the Civil War, of the bombing of Hiroshima and Nagasaki, of the bombings of Tokyo and Dresden, as analogies. They're like, why can't Israel do what was done there? And this a little bit oversimplified answer is because the international community decided after the Second World War that that would no longer be a legitimate means of warfare. But my co-panelists probably have a better and richer understanding of that than I.
I don't know, Vaughn, if you want to jump in at this point. No, okay. I do want to turn a little bit in our final minutes. And I just want to remind the audience, if you have not yet done so, you can submit a question via the link in your reminder email or a QR code on your screen. I do want to turn to the question of what has been happening with the ICC, both in terms of the Trump administration and its relationship to the international court system, but also what we saw really recently, just a few days ago, when Benjamin Netanyahu flew to Budapest and met with leadership in Budapest and was fine. Nothing happened, even though Hungary is ostensibly a member of the ICC or a signatory. What does that mean in terms of both the legitimacy of these courts, and what does that mean in terms of, I guess Viktor Orban specifically, but what does that mean for the court going forward and how we think about these arrests and how the court is perceived? I could go to anybody. I'm going to jump in for them. Kevin, you want to go over there? Yeah,
I'm happy to weigh in.
Yeah, sure.
You know, it's a trite cliche to say that the ICC does not have its own army. It does not have its own police force. The ICC is completely dependent on the cooperation of states in order to obtain the suspects it needs, to obtain the evidence it needs, so on and so forth. That's a challenge. It's a challenge in the Palestine situation. It's a challenge in every other situation that the court has dealt with over the past 20 some odd years. It is deeply frustrating to the court when a state that has made the choice, and it is a voluntary choice, to join the ICC, to ratify the Rome Statute, decides not to live up to its international legal obligations that are clearly spelled out in the court's founding document. This is not the first time that a state has done this. Omar al-Bashir, notoriously, even though he was facing genocide charges, was able to travel safely to, I think, at least a dozen states that were members of the court in good standing. None of them were willing to arrest him. There was a big, long litigation involving Jordan's refusal to arrest him when he was present on their territory. So Hungary is really just the latest and probably most glaring example of a state not cooperating with the court despite having a legal obligation to do so. I do think it is a particularly problematic situation for the court because Hungary is also a member of the EU, and the EU is deeply committed to the International Criminal Court. This is the first time that an EU member has refused to fulfill its obligations under the Rome Statute. The court is going to pursue some kind of disciplinary action against Hungary. They've asked Hungary to explain why Netanyahu is allowed to come to the country without being arrested. But ultimately, the court doesn't really have any disciplinary power. The most that the court can really do is refer Hungary for some kind of sanction to the Security Council. But of course, we know that will go nowhere because there would be a veto either from the United States or from perhaps even from Russia. So this is the situation the court always finds itself in.
Hala, going back to a question somebody asked a little bit earlier, and this actually reminds me just because of what Kevin just asked. Does the United Nations play a role in these tribunals? Do they have a say in the ICC or the ICJ proceedings?
Of course, in the Rome Statute, Article 16, I mean, there's a reference to the Security Council. The Security Council can, under Chapter 7 decision, halt or stop an investigation for a period of 1 year. Stop the investigation, I mean, the court of dealing with the case for a year, and then it can be prolonged for another. I mean, it's not specified in the article, but I mean, if your interpretation of this article might suggest that it can be renewed again and again and again. So there is a role to the Security Council in the Rome Statute. Okay, so because sometimes when we talk about accountability, we talk about there's justice, accountability, there's peace. So sometimes maybe in specific area, if the Security Council is, negotiating or trying to negotiate a peace settlement, and the court is involved in investigation of violations of international humanitarian law, then politics come into the matter, and they say we'd rather let these people solve the issue, let them give them time to maybe to reach a peace agreement, and let the accountability measure just to freeze the process for a while. That's why. So the Security Council is responsible for peace and security in our world, and it has a role in the Rome Statute. And of course, the ICJ is the court of the United Nations. It's the official organ. It's the it's the legal, yes, organ of the United Nations. So if there's an advisory opinion, and the advisory opinion, the court needs help, then I mean, naturally, it can go to the Security Council, and the Security Council should help the court facilitate, or I mean, try to implement the court's decisions. So, like when the war in Gaza, there was also the question when they asked for provisional measures. South Africa, they maybe thought maybe the ICJ would I mean say that both sides, I mean, Israel should stop the war on Gaza. Everybody anticipated that, but actually the court cannot do that, yes? Because, so there's also here a role for the Security Council. Kevin, if you'd like to add anything.
I'm going to actually ask one last question because we are almost at time, and I will add to that as well, because you've brought up the word accountability, and that came up in one of our final questions, which was why is accountability important in international conflicts? But I actually would say, how do we even measure accountability in international conflicts? And they also asked, what does justice look like in the Israel-Palestine situation, which feels to me like another panel, given the amount of time we've got. But I want to actually go to Marty and ask him that accountability question first.
Thanks,
if you want to take
Sarah.
on justice, you're welcome to. But
No, Sarah, such big, broad questions of what would justice look like, what would accountability look like, I think are outside my remit. I don't think that accountability will be found in criminal proceedings in either tribunal. That doesn't make what these tribunals is doing irrelevant or not or worthless. I do think at least last year, until things changed so radically in the world, that what these tribunals was doing was having an effect in Israel, in the United States, and in the international community, and in support and in weakening or at least challenging Israel's campaign, right? And trying to bring an end, putting pressure to bear on Israel to figure out a solution here that would result in far less humanitarian harm. I don't know that that's true anymore. Um, and so I don't really have a good sense, either of whether in Europe or elsewhere, the actions of the ICC and the ICJ going forward, which might be many months or years away, really, honestly, um, until anything of great note happens, will be the principal drivers of the end of this conflict or any kind of resolution. And whether that results in accountability or justice, I would leave for people, for others to assess. But Hala, Kevin, I wonder what you think of that.
I don't know if each one of you give me a few last words, Kevin.
I could, yeah, just very briefly. In some ways, I'm a terrible person to ask this question to, because most international criminal lawyers have a very expansionist view of what this particular area of law can accomplish. They talk about deterring future crimes. They talk about promoting truth and reconciliation. I don't particularly think international criminal law is very good at any of those things. I'm don't think it does sometimes have a deterrent effect. Sometimes it may contribute to peace. But I think I have a very Arendtian understanding of what international criminal tribunals do, and that's they're there to separate the guilty from the innocent. We bring charges against people who we think have committed serious international crimes. We provide them with a fair process, and hopefully the guilty ones get convicted and the innocent get set free. That's really all that we can do. And to me, that's what accountability looks like. A fair process resulting in, hopefully, after a fair process, a conviction. And if we try to weight the ICC with all of these transformative expectations, well, then there will be even more reasons to be disappointed in what the ICC can deliver. At best, it can remove certain what are often called conflict entrepreneurs from a situation and allow other processes to take place. It is probably good that Charles Taylor was removed from the Sierra Leone, Liberia situation. It was definitely good that Milosevic was removed from the Balkans. It would be a good thing probably to promote peace if Vladimir Putin was convicted of a crime by the ICC and no longer the head of state in Russia. But again, what the court does is it brings charges it thinks are justified by the evidence, and it tries to obtain convictions, and really nothing more than that.
Hala, last words, and I'm sorry you have about
Yes.
45 seconds.
Briefly, yes. I think we should go back to where it started. I mean, after the horrible atrocities in the Second World War and the Nuremberg trials, I mean, it all started that the international community said never again. Well, the never again, we want accountability, because victims need vindication, rights of victims. People have to feel that there is still somebody in this world is doing something about it, because when we talk about conflicts in our world, I mean, each conflict has its own unique circumstances. But if the sides want to get a peace settlement, but they need still accountability measures, because without accountability, it's part of the whole story. People need to say we are sorry. People need to say we did horrible things. But the court, I mean, I think that the international tribunals, the ICC, the existence of this tribunal is quite still very, very important, because I think it's supposed to deter states to do their obligation, which it's the obligation of the states to investigate when there are violations, to remind them of the responsibility that if there are violations, you are the ones to investigate, and if there are evidence, you should prosecute and indict. So I think it's a very important, and I think it's an important, we cannot give up the international order that was created after the Second World War. I mean, it's collapsing before our eyes. I hope it's only a crisis time now, and it's like a turbulence or a storm, and it's going to pass. I don't know. Well, we'll hope it's gonna pass.
I will. That was a sobering ending. Unfortunately, that is time, and I want to thank Marty, Hala, and Kevin for taking time out of your busy schedules, and Hala and Kevin for staying up extremely late, both of your times to discuss uh, this incredibly difficult conflict. I'd like to thank everyone at the Hopkins community who tuned in to listen to our conversation today and over the past several months. And for information about the Alexander Grass Humanities Institute, I will tell you to Google the website because it is too long to read out. And you can find more free public virtual content on hopkinsathome.jhu.edu. Thank you again all for watching. Thank you to my panelists for really elucidating an extremely difficult subject in a very short amount of time. And good night, everyone.
Thank you,
Thank
Sarah.
you.
Thank you, Sarah. Thank you,
Good night.
and Marty.
Thank you. Thank you.